lecturer here at the Department of Law at the University of Winchester, and we sort of have 6 speakers here for our final plenary discussion. I suppose in many ways to summarise everything that we've looked at so far during the course of this day. And essentially the format is we'll have each of our 6 speakers will speak in turn for 5 or so minutes, maybe a bit longer, and then we will open it up for questions. We'll spend the rest of the time with questions. I must say, of course, I'm a replacement for Marion, who unfortunately can't be here, so in case you've not realised. Our first speaker is Detective Superintendent Paul Barton from the Hampshire Police. He's been a police officer for 24 years and is now Senior Manager in a number of areas, including intelligence, homicide and kidnap, professional standard anti-corruption and child abuse investigations. Which sounds like a heavy sort of portfolio of areas. So Paul is going to talk to us about there's been much debate about the privacy of those who are subject to a state record, under surveillance, or who may be part of a bulk data set. So Paul's going to think about the rights of victims or potential victims, or those who might benefit from data analysis. So, over to Paul.
Thank you, and thanks for inviting me today. It's been really interesting listening to some of the debates, and actually I was quite surprised, pleasantly surprised, that I think a lot of you seem to be on a similar wavelength to me, which is, I was expecting a bit of a battle today, but actually, apart from the lady from this morning from Big Brother Watch, I think everyone else is on my side, so thanks for that. I'm not 100% familiar with the IP bill. I've read bits of it, I've been briefed on some of it, and I can see there are benefits there, and I can see there is a need to change. And I think somebody highlighted earlier today about what we saw in the news yesterday going on in Sheffield with South Yorkshire Police. And again, that was 27 years ago, but all it takes is one incident and then the public's confidence just goes downhill again, and we as the police are back to square one to try and rebuild that trust with our communities. So for me, anything we can do that shows our transparency, I think is a good thing. Without obviously compromising our tactics, because we do need to do some stuff very covertly and very secretively. And if we give away all our tricks of our trade, then all that does is help the villains who can then obviously progress one step further again. But to say public confidence for me is key, so that we can ensure that we don't abuse our powers. Some of you may remember, obviously I can because I've got grey hairs to prove it, that prior to RIPA, there really wasn't any legislation that we worked by, and we could pretty much do what we wanted. And I think that was a real issue, and I remember when RIPA came in, and we had various briefings around the police service talking about RIPA and what it's going to mean to us. And we were all throwing our hands up in the air saying, oh my goodness, we're never going to get anything done now, we're never going to prosecute anyone because we're so hamstrung in relation to how we can now investigate people. But the reality is actually RIPA has been a good tool for us, I think. I work with RIPA every day, and I'll go on a little bit more in a minute about what my role is. But actually, I think it's not bad actually as legislation, and there are safeguards in place, I believe, in relation to the Office of Surveillance Commissioner who come in and scrutinise our work. There's various authorities we have to go through sometimes whereby judges from the OSC will look at our authorities prior to giving approval, and then we have IOCA as well, the section of Communications Commissioner's Office, who also do the same thing for communications data. So hopefully that reassures you a little bit that it's just not the police just signing up what they want to do and going off and doing things. For me though, what is key is actually the theme of this conference, which is information is power. And I think, if anything, we've got to have an equality of arms with the criminals that we're looking at. And I think sometimes if we constrain law enforcement so much, then the only people that are going to win at the end of the day are the criminals and not the victims and the communities that we're trying to protect. So just to talk about the topic that I've been asked to look at, which is what about the rights of the victims and potential victims who might, and others who might benefit from data analysis. My job is in law actually. I'm a Detective Superintendent and I'm a Force Authorising Officer, so I am responsible for all covert operations that happen in Hampshire and the Isle of Wight. I'm also the Senior Responsible Officer, so I'm also responsible for all communications data, applications and breaches as well in relation to Hampshire and the Isle of Wight. So my job's quite unique in that I'm independent, so I don't investigate crime, or if I do investigate a crime then I can't then authorise my own activity. So I sit there with applications that come in on a daily basis. I have to take a step back and I have to consider what the intelligence case is, whether it's proportionate, whether it's necessary, whether it's justifiable. But also one of the main things I need to consider is the collateral intrusion. And that is the intrusion on innocent parties as to what is this data going to give us. And for instance, drug dealers we are looking at all the time. Drug dealers operate by phones, as you probably know, particularly the students in the room. I'm joking. They are very clever. They are organised criminals, and they will buy bulks of phones, handsets that cost £10 from Tesco's with numerous SIM cards. They will use them literally for an hour's worth of communication, and they will destroy those phones and they will dump them. They are still a little bit stupid, fortunately for us, because that's how we catch them. So they still do things like top-ups. They still go to areas where there is CCTV. So obviously we exploit that data by then gathering and harvesting the intelligence and the evidence from them. But to say, what I then need to look at is, if we're getting data, say for a 3-month period of a known drug user, what are the chances of innocent members of the public also being in touch with that number, and how are we going to manage that? And you know, what I say, I have to give strict guidance in relation to that. So what I will say is, with all the data that we're going to capture, I need to make sure that when we do research those numbers, we use systems that are already available to us. So open source research is a good example. Is that number already in our crime system recorded? They might be a member of the public who's rung up to report an incident. So we can just actually cross-reference that number with who that person is, then hopefully eliminate them from that inquiry, and then focus on the real criminals that we're looking at. And then what I say with that product is that they cannot action that unless they can justify it. So they cannot then have a number that they think is a bit dodgy and they want to do a bit more work with it. They then need to go through another application process to give it to me or another designated person that actually is proportionate, necessary and justified. So I'm hoping that kind of gives you an idea of the kind of the scrutiny that we go through, accepting that you might have a view on what police are like and actually, you know, we'll do anything to get a result. That is not the case. It does happen on occasions, but I can certainly say in my thoughts that is not the situation. Now, we use communications data to really good effect, and I've had a couple of homicide investigations, some quite recently that have been in court, where we have convicted people, where we've had no eyewitnesses, we've had no forensic evidence, we've had no admissions of guilt, and what we've used is communications data and possibly some CCTV just to attribute those people to those phones. An example I can give you is that about 3 years ago was an execution in Southampton where a drug dealer was shot in the head by 3 other drug dealers, all from London, but down in Southampton doing their business. No eyewitnesses to that. What we did have was some phone data whereby the offenders were seeking out the victim, so there was some communication there that we got from the victim's phone. With that we then got the handsets of the perpetrators. Clearly the phones were unregistered, pay-as-you-go phones. We've managed to do some work in relation to top-ups. We then got the cell site evidence and managed to put them in a taxi. We managed to then track them all the way out to Basingstoke, where they then caught a train from Basingstoke into London, and the girlfriend then picked them up, took them back to the home address. We then seized their phones, seized the computer, looking at the internet usage of the computer. What we could show is the girlfriend, who was a PhD student who worked in the prisons with her boyfriend. She then did the research on how to destroy a gun. So she was convicted of provoking false of justice and assisting an offender, and she got 5 years, and the 3 murderers got 29, 30, 31 years. So that's a quick example of how communications data and using the internet is really, really key, where you can get justice for a victim. And as I say, we don't discriminate. Yes, he was a drug dealer, but he didn't deserve to die. And the family, black family from Brixton, came down and met me in the major incident room on the day of the murder, which was actually the 20th anniversary of the Stephen Lawrence murder. And, you know, they looked to me as if to say, we know you're not going to investigate this very thoroughly, we know that you're not going to do a good job because you don't really care about my black son who's a drug dealer. And on the day of the verdict, you know, I literally had the mum and dad hugging me on the steps of Winchester Crown Court, which is a really nice moment, you know, but we couldn't have done that without the communications data and the CCTV that was overlaying that. Just very briefly as well, where we look at victims as well, particularly safeguarding vulnerable people. You know, we are regularly using live trace call data to trace vulnerable people who go missing. They either go missing by choice because they're depressed, they're suicidal, they've got mental health issues. We've got people that go missing because they've been kidnapped or they've been abducted. And we have people that, you know, sadly have dementia and they go wandering off. And say by using communications data to good effect, we're focusing on the subject phone, so collateral intrusion is fairly limited but justifiable in my view. We can save a lot of time and resource by focusing on where that phone is and hopefully find the person with that phone and save a lot of lives. People that may not necessarily be in the right mindset to make choice decisions themselves in relation to that. I think that's all I was going to say. If there's anything else, but I can take some questions at the end if that's all right. Has that answered the question?
Yes, I think that has. Thank
Okay.
you very much. Okay, we'll move on now and hear from Dr. Julian Huppert from the University of Cambridge, a lecturer in public policy. Julian used to be an MP for the Liberal Democrats, representing Cambridge. Julian, whilst Julian was in Parliament, he served on the Home Affairs Select Committee, the Joint Committee on Human Rights, and on the Draft Communications Data Bill Committee. He was the Liberal Democrat spokesman on Home Affairs, Justice and Equalities as well. And also, interestingly, I've got down here, Julian was awarded Internet Hero of the Year in 2013 by the Internet Service Providers Association for his work in killing off the communications data. So it shows the power sitting on a committee, I suppose, which in my field is quite a big debate. So Julian is going to discuss, perhaps inevitably given his background, the political and social context in which the debate around data analysis and investigatory powers is being discussed, and sort of considering, is this skewing views in any particular direction? So, over to you.
Well, thank you very much for that. It's lovely to hear such nice comments. I'm not sure I can match up to it all. What it doesn't say is that the people I beat out for that title included Edward Snowden and some guy called Nick Clegg. So, not sure that was necessarily a good thing for my career, but there we go. So I got quite involved. My interest fundamentally is in privacy in a digital age. But I sort of perforce got more and more involved in one particular aspect of that. I'm actually in some ways just as interested in what happens about privacy when it comes to organisations where you've consented to give data, or cyber criminality, espionage, as I am in state surveillance, where there's sort of implied consent. But I got stuck in this one, partly because of the Commons Data Bill, partly because of Snowden. But for what it's worth, I certainly don't think that the only people who can't read my email should be GCHQ. It seems slightly wrong if Facebook can read it, Google can read it, the Chinese can read it, it's just our lot who can't. I think we're in a really interesting time, and the amount of data that we have has changed massively, and the legislative processes have struggled to catch up. If you think back 20, 30 years, the idea that there'd be so much data, digital data available on us, just would seem unimaginable. That the things that can be done, we just had an excellent description of some of those things, could not have been done before. Drug dealers 20, 30 years ago didn't have mobile phones everywhere that they were going, they weren't following each other, they weren't Googling how to get rid of a gun. That data simply wasn't available. So there's been a huge growth of that sort of data, that sort of coverage. And that has led to a huge growth in collection, some of it very useful, some of it more problematic. And unfortunately, and I think David Oman talked about some of this earlier, we went through a phase where a lot of the powers were really never spelt out. RIPA was an improvement on the complete absence of anything we had before, but it is still desperately confusing, desperately unclear, and has huge problems. That was far from the only one. I got quite interested in another piece of legislation being used, Section 94 of the Telecommunications Act 1984. How many people up here have actually read that? Good. It's good to say, you know, a couple of years ago that number would have been 0 because nobody noticed it. Would have been 1, sorry. Would have been 2. I was talking about the audience, of course, not you two, who I know. But nobody was aware of it, nobody was interested in it. But just to give you an idea, because it really is astonishingly broad, it's worth having a look at the legislation we had. This was a power to say the Secretary of State could give directions to a telecommunications company, directions of a general character as appear to be necessary in the interest of national security or relations with the government of a country or territory outside the UK. You can do anything for national security or relations with somebody else. So if the Americans ask you to do it, that's fine. Now the legislation is quite clear, because that's such a powerful clause, it has to be reported to Parliament any time it's invoked. Unless doing so would risk national security, relations with another country, or commercial confidence. Can you guess how many times it was reported to Parliament that it was used? Correct. It's only recently been avowed this was used very, very extensively. That is an incredibly broad power. When, after a lot of fuss, we got one of the commissioners to have a look at it, he commented that, firstly, he couldn't tell anybody what he'd found, but secondly, because any Secretary of State could do this, and there was no database kept of when they were used, he couldn't even be sure that he knew about all the cases where they had been used to find out whether or not it was appropriate. That is the sort of legislation that we had. Hugely, hugely problematic. As an aside, do you know how long it was debated for in the House of Commons or the House of Lords? They ran out of time on that day, and so didn't get around to discussing it at all. Not a word was said about it. And actually the printout of the page was missing from the library, but that's, I'm sure, just coincidence. So we've had those sorts of things. And we have a constant desire for more powers. Now, some powers are absolutely appropriate, but there is a tension here. Let's imagine you are in charge of an agency, and you are asked by the Home Secretary, do you have every power you would like to keep us safe? What answer are you going to give? If you say, yes, we have every power we need, you are exposing yourself to huge risk afterwards. So there's a huge pressure to say, no, we don't have the power to do this, this and this. The same applies to a Home Secretary. The risk of saying, no, we don't need this thing. What happens if there is a terrorist incident and people later say it could have been prevented if? So there's a huge tension pushing for more and more powers, and there's very, very little pushing back the other way. And that, I think, is a really big problem. We see lots of rhetoric around it, this Home Secretary in particular. It's always about terrorists, paedophiles, gang members. It's all the big things. It's not the rest of the use. So I think there is a real problem there. There's also a problem that the evidence base is often extremely thin for what is being done and for what might be done with new information. Let's say communications data. I think the case, by the way, is absolutely clear that communications data is incredibly useful in a number of cases. But how useful, actually? How do we work out how often? And the key question really does have to be, how many of these cases could not have been tackled without communications data? And that will be some of them, and it won't be others. But you have to have some sort of sense of that to know how much money, how much resource, how much effort is it worth putting into that, or the next phase. If you keep web logs for everybody, how many extra cases can you deal with versus the cost? If you don't know that, you can't make a sensible decision. The cost when we had the communications data bill, which was described, I'm pleased to say, by the committee that I sat on, slated it more than any piece of legislation in the history of Parliament by a draft committee, described all of the things as misleading, but they were saying £1.8 billion would be the cost over 10 years. Is that actually the best use of money for policing? Could you do a lot more with some more police officers? Not just that. So cost and resources matter. Let me give you another example of where resources are. One thing that frustrated me. Has anybody here heard of Project Spade? So, right, no, okay, fantastic. So Project Spade was a really interesting illustration of where some of the challenges lie for the police about resourcing. So the Canadians broke a child abuse ring, and they captured the computers which had records of everybody who purchased stuff from them. And so they sent to everywhere around the world information of people who'd been buying these child abuse images. And in the UK there were 2,345 names with, I think, credit card details, addresses, quite a rich data set. Very interesting, very, very detailed. And the UK, see opposite was at least, didn't do anything with it because they didn't have the resources to look at those names. Now this was at the same time as we were hearing the pressures for more powers to tackle paedophiles. And it wasn't for, I think, 16 months before anybody looked. And one reason I care about this is because one of the people who was on that list was a paediatric oncologist in Addenbrooke's, my local hospital, and was abusing children. And had anybody been alerted, 14 months of abuse would have been stopped. So do we want more powers, or do we want more resources to look at the data that we have? In, I think, every terrorist incident, we find that the people involved were already known to police or the agencies. There was some information already. Should more resources have been applied? How much money do you spend on more powers? How much money do you spend on the resources to actually do things? And there is a big downside to any of this. Let's look at the idea of the internet connection records, keeping a log of every website you ever go to. Now, yes, it's only up to the first slash, so if you look at Google, we don't know what you searched for. But if you go to thedepressionalliance.com, can anybody work out anything about your personality from that? If you look for marriage guidance or abortion counselling, there's lots of really intrusive data there. And data will tend to leak. Either accidentally, we've seen lots of cases of that, well-run things like the OPM in the US, which looks after federal employees, where they lost huge amount of data, social security records, fingerprint records, or it will be lost through deliberate abuse. Love it. People looking up, where has my girlfriend been? Can I track that? And there have been cases of that here and in the US. So I think that's a big challenge. I think there are things, by the way, where we should be going ahead. So we pushed, after the Comms Data Bill, for IP matching, which was the power that the police actually said was the most important new power for them. They could evidence it well, and we wanted to see it happen. Interestingly, the Home Secretary resisted that for quite a long time because she wanted more powers. I could talk about the politics of this perhaps later. Two other things, and then I'll shut up. One is we need to think about how this is seen internationally. Because I think we are very lucky to have police force who are, in almost all cases, honest, decent people who are trying to do the right thing and really do believe in protecting privacy, really do care about that. We have policing by consent. We have agencies that really do try to do the right thing. They may not always get it right, but they are trying to get it on that right side. That's not true around the rest of the world. When we look at powers which say the Prime Minister can appoint somebody to do the following, and you think, would we buy that in Russia? Would we buy that in North Korea? Do we want Google and Facebook to be bound by Russian laws that are written in the same terms as ours? I think we have to be very, very careful about that. The last thing I just want to say is about side, because Paul mentioned people being on his side. I'm just going to draw a diagram. I don't have a big enough pen, but I hope you can see it. And this way you can look at it later. People talk about a trade-off between privacy and security. There's always one. Thank you. Trade-off between privacy and security. I don't know about that at all. I think there are two axes. And there's a limit. We can have a certain amount of privacy for a certain amount of security. If you're absolute privacy, you will be less secure. If you're absolute security, you can't have any privacy. I think we're not right on the edge. I think we're somewhere here in the middle. And I think what we need to do is all be on the side of moving that way. And if we come up with things like I think the IP bill is at the moment, which gets us out of the way, we're actually going in exactly the wrong direction. So I think we can be on exactly the same side and boosting both of those, and maybe in theory we'll get there sometime. We're a long way off. Sorry for speaking too long.
Not a problem. That's I like that diagram very much. We now have Dr. Nora Ni Loideain. I'm sorry, is that right? That was nowhere near, was it?
No.
How would you?
But it's fine. It's fine. People in Ireland get it wrong all the time, so there's no blame. It's Nora Ni Loideain, which is.
So I've never got a few minutes. Okay, well, Nora is a research associate for the Technology and Democracy Project within the Centre for Research in the Arts, Social Sciences and Humanities at the University of Cambridge. It's a very long-winded centre. She completed her that's a very long name. But she completed her PhD at the Cambridge Faculty of Law in 2015. And in 2014 she was a visiting researcher at the University of Cape Town in the Faculty of Law. And previously was a legal and policy officer for the Office of the Director of Public Prosecutions of Ireland and clerk for the Irish Supreme Court. Her research publications and teaching focus on governance, human rights and technology, particularly in the fields of digital privacy, data protection and state surveillance. And she's going to talk about how oversight should operate, and really the issue of judicial commissioners and whether they should be able to override elected officials or those in operational roles, and the constitutional impact that this may have. So, over to you.
Thank you very much, Craig, and thanks to Marion as well for the invitation today. It's a really fantastic event, and it's so wonderful to be part of an event about information and privacy and risk and trust, where it's not just academics, it's not just policymakers, but it's the institutional actors like Michael and Paul. You know, it is academics, it's all the different disciplines. So it makes for a much more interesting and I think much more real conversation about the actual challenges involved. So yes, Marion sent some questions ahead for this panel in terms of what we were going to address, and I have my 3 questions, and I have to say they're quite substantial, so I'm going to run through them, and then if I can follow up in much more detail in the Q&A session afterwards, I very much welcome questions then. So the first question that was directed was how should oversight operate within the context of covert surveillance? And the very short answer to that is within the parameters of the law. And as a lawyer, of course, I'm about to tell you all the other details that come with that. But essentially, under the Human Rights Act, you know, public authorities, the courts, they all have to conduct and exercise their duties within the parameters of the European Convention of Human Rights. And this includes the judgments by the national courts here as well. In terms of the European Convention of Human Rights, which has been the leading standard on this area since the late 1970s, the ECHR has established a range and very rich, detailed number of minimum safeguards and principles and conditions that states across the European Union now have all adopted and have updated their laws with. This is the reason why the Interception of Communications Act of 1985 then became much more detailed and arguably much more helpful to public authorities in RIPA. The same again with RIPA, and we shall see for the IP bill. So, in terms of what falls within Article 8 of the ECHR, as other lawyers have brought up today in their presentations, we know that covert surveillance is an interference with the right to respect for private life under Article 8.1. And we know that the court has updated this in terms of keeping up with technology. So any processing of private information constitutes an interference with Article 8.1 of the ECHR. The lawyers among us and other people here have already addressed today that the European Union Court has gone even further, and it's the interference with any personal data that will constitute an interference with the Charter, but we can talk more about that later on. So we know that a high standard of safeguards and guarantees has to apply throughout the surveillance cycle of information when it's being processed by public authorities. And this includes the retention of information, the authorization, the access, its use, its analysis when it's shared with third parties within the government, its storage, its deletion, and its destruction. And in line with the ECHR being interpreted as a living instrument, those standards have been updated. So back in the late 1970s, the focus was on telephone tapping. But even then, with a judgment in 1985, Malone versus the UK, the court had the foresight to focus on how much communications data revealed with regard to call data from who you call, when you call them, the devices you use. And it's since been updated to the communications data we now can glean from the internet, so any internet usage data, for example. And these standards also apply to mass surveillance regimes. They didn't always, but the law was changed on this with Liberty versus UK in 2008 because we now know how significant these powers are and how often they can be used, and often legitimately, by public authorities. So the principles underpinning these safeguards, legality, necessity, and proportionality. We know that these laws must have a basis in domestic law, so in practical terms we know that there should be a statute, there should be codes of practice. It must be accessible and foreseeable, so the public must have access to this. Also, it must be comprehensible. We need to know what it actually means, And of course, there is a fine line within the area of covert surveillance. You don't want criminals being able to know whenever the police are going to intercept or plan to circumvent their activities, or terrorists either. But at the same time, citizens need to know how far these powers go. So that's a balance that the court manages often. It must be in pursuit of a legitimate aim. So whether a case is brought before the court in Strasbourg or Luxembourg, this isn't often contested, because legitimate aims such as the prevention of serious crime or terrorism is something that the parties will always concede. But most people are on your side, Paul, in terms of legitimate aims, and people realizing that yes, criminals and terrorists do exist and they do mean us harm. So, the second question that Marianne directed was, should judicial commissioners be able to override elected officials and those in an operational role? So people like you, Paul and Michael, and now I'm sitting between them, and it feels slightly awkward when I say this. But on the basis of the European Human Rights Standards, which is what I've been directed to answer this question on, the European Court of Human Rights says that yes, judges should be the optimal oversight control for these kinds of powers. And this is based on the following grounds: that abuse of this area is potentially very easy because it operates so secretly. And also because judicial control offers the best guarantees of independence, impartiality, and proper procedure. And in terms of what that means in terms of how compliant the new regime proposed under the IP pillars, maybe we can discuss that more in the Q&A session, because I can now move on to the next question, which is, what does the European Convention of Human Rights and the EU Charter, case law from both of those systems, tell us about oversight of covert surveillance? So, even though the European Court of Human Rights would like to see judicial control of covert surveillance in every member state, it considers it to be the most optimal form of review and oversight. It doesn't have to be judicial. It can be non-judicial. If it is, it has to be sufficiently independent from the executive or from the operation of the covert surveillance. So Paul essentially shouldn't be authorizing all of the surveillance powers that are accessible to him, for example. And provided that this independent body, which may or may not have, the court is much more likely to deem a particular regime compatible if someone who is a serving member of the judiciary or has been a serving member of the judiciary is part of this body. So provided that they're sufficiently resourced as well, that's a key question. They should be able to provide meaningful review and accountability. If the scope of review is limited, if their resources are hampered, the court will find very strongly against this, and it did so in a recent case against Russia, whereby it was very much in favor of the fact that there was judicial oversight, but then when it looked deeper into the circumstances, it realized that there was no logging of any of the surveillance measures used by the police or the security authorities. So there was no way to measure if these measures were even working, how far they were being used, no scope for review or control for any oversight body. So effectively, judicial control was meaningless in that sense. So, this brings us on to how else oversight can be accessible, and it can be accessible by annual reports, which is what currently happens under the regime here, by the different commissioners, including the IOCCO. Also by reports to Parliament as well. The Strasbourg Court would also be satisfied if a public independent body was consulted on these reports also, as an alternative to Parliament. The covert surveillance regime must also operate in a way that statistical information is being gathered, and it's very welcome that under the IP bill, statistics are going to be gathered and they are going to be assessed in annual reports every year. Unfortunately, there is a current provision that the Secretary of State will be doing her own review of the legislation instead of the joint parliamentary committee that's been put forward, and this is in place of a sunset clause for those powers. So we'll see how the amendment process goes as the IP bill is going through Parliament. In terms of EU law, I know for the lawyers in the room certainly that most of you are aware, it has been raised earlier on today, that there is currently a major case before the Luxembourg court, And this is the joint case of Davis and Watson and the Swedish administrative court as well. So currently, under EU law, which was established in the landmark case of Digital Rights Ireland, so this is when the European Court made history by striking down an entire directive for its incompatibility with the right to respect to private life and the protection of personal data under the EU Charter. It laid down a number of very detailed, prescriptive and stringent oversight arrangements that the European Court in Strasbourg hadn't previously enforced. So, for example, in terms of processing information, the Luxembourg Court deemed that in terms of surveillance oversight, there should be prior judicial oversight or prior oversight by an independent body. Now, as was mentioned earlier on in a session this afternoon, the European Court in Strasbourg is less prescriptive. These assessments of the laws of national states are done on a case-by-case basis. All circumstances are considered. This is very much a departure from that approach, and this is very, very prescriptive. And what the Court of Appeal in the UK has tried to clarify by sending this preliminary reference to the Luxembourg Court is the question of, in Digital Rights Ireland, when you set out these very prescriptive and stringent safeguards, is this just within the context of EU laws that deal with the processing of personal data? Or does it also apply to national laws as well? I think the Court of Appeal certainly made clear in its judgment that it's hoping for the case to be that Digital Rights Ireland was just being descriptive and not prescriptive to the national states. However, there is a fly in that ointment because there was a subsequent judgment that some of you may have heard about, Schrems, last year. And in that judgment, the Luxembourg Court was very happy to strike down a trans-border transfer of personal data framework between the US and the European Union, which has caused much consternation between the public authorities and the corporations affected by this exchange. And it effectively transplanted the standards from Digital Rights Ireland to this personal data exchange decision regime. So it's looking quite likely that the court may indeed decide that these same standards should apply to national courts. But this is me with crystal ball gazing, so we will have to see what the Luxembourg Court actually delivers on this, and the judgment will be delivered possibly in July, because the Advocate General who advises the court delivers his opinion then, and the judgment's also been subject to expedited proceedings. So, any questions on any of that afterwards would be very welcome. Thank you.
Okay. Thank you very much. I think crystal ball gazing is always a dangerous game. It's sort of, whenever I've done it, I've always got it spectacularly wrong, so hopefully more successful than I am. Now, we now have Michael Scott, who is an intelligence manager for the ACRO Criminal Records Office. Previously, Michael was a police officer, working in investigation teams in homicide, sexual offences and other serious crimes, so another nice light portfolio of work. But now in ACRO, which he joined in 2010, his work is to develop intelligence capability, taking opportunities to share information on serious crime and conviction of foreign national offenders. But also one of his responsibilities is to lead a public protection team which manages records of both UK sexual offenders convicted overseas or foreign nationals who have such offending in their home country. Okay. Over to you.
Okay, folks, ladies and gents, good afternoon. It's always good to be in academia. Today I've learnt the name of Romulus and Remus' mother. IT type conferences tend to normally find me out. My limit of these things is attaching a document to an email and sending a calendar invite. So, but I have actually learned or absorbed much of what's been going on. Some other things I'm afraid I haven't, but there we are. My questions that Marion posed to me, or the points that she asked me to cover, are hidden in the script, so I'm not actually going to make those points. And I'm also going to read my script because otherwise we'll be here till late in the evening, because once I start I'll really have to be hauled over to be stopped. I've already gone off my script. I'll leave you to consider and interpret my points later on. Okay. 3 words: Paris, Brussels and London, in fact London twice. I don't imagine that I need to remind you, Sir David has hinted at it, of the very recent events where around 130 people were killed and hundreds wounded in 5 attacks on the 13th of November 2015 in Paris, and where more than 30 people were believed to have been killed and dozens injured in bombings in Brussels International Airport and at a metro station on the 22nd of March, just a few weeks ago. I was reminded of the events in London on the 7th of July 2005 when 52 people were killed and hundreds more were injured on what was described as the worst single terrorist atrocity on British soil, which is going some considering the 2 decades of bombing, Irish bombing we had around the United Kingdom before then. When asked in the last couple of years, is the UK any safer now, the BBC's security correspondent Frank Gardner said yes and no. I wish I could answer all my questions yes and no. It'd make my life a lot easier. He was partly able to answer in the affirmative because of the successful number of foiled plots. Again, Sir David hinted at this morning, earlier on, in the UK, including one which we continue to be affected by, today, the aircraft plot in August 2006, which was designed to create liquid bombs disguised as soft drink bottles with the intention of bringing down transatlantic flights to the United States. This did and still does bring inconvenience at airports, as liquids have almost been entirely banned from hand luggage on planes today. In London in August 2006, information was power because it allowed for security and law enforcement to make decisions about the means to deal with the real threat to hundreds of passengers looking to take transatlantic flights. In Paris, Brussels and London, more recently, London 2005, there was no power afforded to the authorities to prevent the bombs because the information about these didn't exist, or it was ignored, or the response required was not resourced. At a less impacted level, information is power when law enforcement decisions based on principles of movement and freedom linked to the justified and proportionate sharing of information across state borders look to prevent and reduce the risks of crime. I don't intend to make any political comments about political membership in Europe. Seriously, I don't. But there are law enforcement benefits. Europol, Schengen, lots of people hear about Schengen, but I'm going to specifically talk about, I'll mention SIS-2, which allows for alerts on people of interest. And of course, notwithstanding EU membership, Interpol. These allow for sharing of information on criminality and alerting member states of potential risks by persons. Transitory movement of serious criminals can be problematic. No one knows really who's moving around Europe, or indeed the world, unless there is proactive sharing of information where they travel. Some areas of Europe have different rules on record keeping. In a number of member states, criminal records are expunged even for serious offences after a period of time, often just 10 years after the offender has completed their sentence. Strong views, probably due to historic regimes held in Central Europe, about freedoms after sentence, and offenders can be released from custody without any further restrictions. Arnis Zalkins, as everyone now knows, was convicted in Latvia of murdering his wife, but the rules of conviction histories, including the expunging of the record after 10 years, When the United Kingdom asked Latvia, following his link to the Alice Gross murder in 2014, if he had convictions, they were advised, according to their records, that he did not have convictions. The United Kingdom was ignorant of the risk that he posed. Robert Mickelson was born in Riga and was convicted of possessing child pornography in Germany in 2003 whilst working at a daycare facility in Heidelberg. He became a Dutch citizen in 2008 and was later convicted there of sexual assault on children in his care. Again, no one shared his criminal history proactively, even for public safety reasons. Try and get back to the point that we've been discussing today. Technology has changed the environment, and free access to data creates the ease to share and store, and we're rightly discussing how this will affect our privacy against protection. And we must be able to find a safe balance. It's interesting, for example, that the overwhelming use of ANPR, the automatic number plate don't get old folks, is commercial and not used by the state. There's something around about 90% of ANPR is used by Tesco, Sainsbury's, Southampton City Council, etc. In days where money talks, and I know people have been talking about money, the fiscal aspect to investigate and repair after terrorism should be taken into account, at the same time considering the access by the state of commercially collected material, where proportionality and reasonableness should be the key. Okay, coming to the end of my points. This is a part of an executive summary of the report of the Independent Surveillance Review, and a document called A Democratic Licence to Operate in 2015. The report stated, despite the disclosures made by Edward Snowden, we have seen no evidence that the British government knowingly acts illegally in intercepting private communications, or that the ability to collect data in bulk is used by the government to provide it with a perpetual window into the lives of British citizens. On the other hand, we've seen evidence that the present legal framework authorising the interception of communications is unclear, has not kept pace with developments in communications technology, and does not serve either the governments or members of the public satisfactorily. A new, comprehensive and clearer legal framework is required. Ladies and gents, failure to collect and share information could be an act of state neglect.
Thank you very much. Thank you. We now have Graham Smith, partner at Burton in London. Graham's practice is in the internet, IT and intellectual property, and is one of the UK's leading cyber law experts. He gave evidence to the Joint Committee scrutinising the draft Investigatory Powers Bill, and is one of the co-authors of the leading textbook Internet Law and Regulation. Graham is going to talk about how law and society should deal with advances in technology and changes in personal behaviour. For example, we move from telephone to online communication. So, over to Graham.
Well, thanks very much indeed. I hope you can hear me. I'm afflicted by horrible logie, so the shouting will come. Yeah, as you can hear, I come at this with a background as a sort of IT and internet lawyer. I'm not a criminal lawyer, I'm not a law enforcement background, I'm not a human rights lawyer, I'm not a public lawyer, so I come with a number of disabilities. But from my IT and internet background, I have encountered RIPA in particular from time to time over the years from its inception, and I had the misfortune to be aware of Section 94 of the 1984 Act and wonder about it from time to time. Perhaps one of the earliest people to do so, I don't know, other than those who knew what was going on, of course. Excuse me. However, you will also gather that I have a particular interest in the Investigatory Powers Bill that's going through Parliament at the moment, and I'm going to focus most of my comments on that. It's, as I say, it's going through House of Commons committee stage at the moment. It's being subjected to a thorough analysis and forensic analysis, I think it can be said, particularly by Joanna Cherry and Keir Starmer for the SNP and Labour in particular. And already I think we can see the Home Office issuing more letters to the committee explaining various parts of the bill in more detail than I ever saw during the passage of RIPA, which I was around to remember. Some of the issues that are sort of coalescing and crystallising as it goes through, I think are largely the ones you would expect. The concentration on scrutinising the bulk powers to collect content and data on a suspicionless basis. there's an increasing recognition, and not before time, I might say, of the implications of collecting not content but metadata in bulk. No one, I don't think, even the government, I don't think, is really anymore saying, don't worry, it's only metadata. It's appreciated now that the metadata is vastly greater in volume and richness and potential intrusiveness than had perhaps previously been appreciated. And so there is a shift, I think, in the perception of the sensitivity of metadata compared with content. The issue of why many of the powers that previously only applied to public networks are being extended to private networks, including potentially, in principle, private homes, offices, hospitals, universities, schools, has started to be addressed. I don't think there's been a satisfactory answer or justification, even an attempt to justify